couple of issues that we have raised for your consideration is whether there was a relinquishing of jurisdiction to a marital asset to a pending case in Chancery Court in the same county regarding some insurance proceeds that we argue was a marital asset of the divorce, and the disposition of that asset was left to be determined by the Chancery Court, by the Circuit Court.
That was a claim for insurance.
It was a claim for insurance. Both of the parties, Your Honors, were parties to that case that was happening in Chancery Court in Macon County, and it's our position, Your Honor, that of course, there would be an award if there was an award. Whatever award would come to that would be, our argument is that should be treated by the divorce court as to its division. There was an award as to the marital residence itself, but this was the burning down of a house that happened during a marriage. And when the house burned down, then there was some disagreement, I guess, with the insurance company. A lawsuit was filed by both of these parties at the time, and there was not a divorce pending at that time, but the case actually lingering long enough to last during the divorce happening is our position that the ultimate division between the parties themselves would end up being something that decision for the Circuit Court, which had jurisdiction in the divorce.
And your position is there's no dispute that house and property was a marital asset?
Some things for the court's edification. The house was actually only in the wife's name, but there is evidence in the record where my client actually placed $186,000 from the sale of a separate property in Clarksville, and it was incorporated into that marital residence that's in Macon County. Ultimately, that house had a fire and then was burned down, which pretty much places these folks at zero, I think, and puts them at scratch. So it would be our argument that is absolutely marital property now, and the marital property was determined to be marital property by the trial court in the hearing. It's just that she wouldn't exercise any jurisdiction over whatever the award was going to be in Chancery Court, because the problem in Chancery Court, the court needs to be aware of, is that the only person left in that case, somehow or another, along the way, there was a default judgment entered in against Mr. Garrett, and he was no longer able to be involved in the proceedings in the Chancery Court case. So it was simply our argument to the trial court in the divorce is that, well, it's an asset. It's going to come into the consideration of the Circuit Court for disposition, or in other words, on how it's distributed. Ultimately, there was $79,000 arrived or realized from that Chancery Court case, and it was our argument that it should be distributed by the Circuit Court. Circuit Court had entered an order back in July of 2021. I think it was July 2nd of 2021, where that court says, well, we're going to let the Chancery case continue, and we'll let them decide on how that case is going to be distributed. Ultimately, the chancellor in Chancery Court did make an award, which that award's been appealed also, but awarded the wife 2/3 of that $79,000 and awarded the husband 1/3, and did state in his holding, he says, well, since the divorce is on appeal, and this is what her ruling was in the divorce, is that the wife will get 2/3 of the marital residence and the husband will get 1/3 of the marital residence. He would divide that $79,000 in that ratio, like 66 and 2/3, and this 33 and 1/3 to the husband, pretty much paralleling her ruling. So that has been the ruling in that Chancery Court case. It's our argument is that, well, we disagree with the way they divided the marital residence anyway. So we've got we have to argue that, well, there's this appeal over here for the Chancery Court, that proceeds should have been paid into the clerk's office. That's what we're saying, and they should have been divided by the trial court.
Counsel, opposing counsel has raised an issue in their briefing in terms of the adequacy of the briefing on this question.
Okay.
It seems like your argument has gone a bit beyond what's in the brief itself. And does your brief adequately meet the requirements to have put this issue before the court and given opposing counsel an opportunity to fully respond to your argument?
Well, in my response is that or at least the way I raised it or briefed it, judges, I would say that we're saying that the courts in the trial, in the divorce, should have had jurisdiction over it because it was a marital asset, and that is about as far as I took it on that. Now, again, though there were some extraneous facts that I included in there, I don't think they will be disputed as far as the way that this money was handled. But I do agree that I pretty much are asking you to say, or this court to say, this is a marital asset, and it really shouldn't be left up to the Chancery Court. It should be left up to the divorce court.
So how do you get it into the divorce court? You tried to get it combined or something, right?
Yes.
You tried to get the divorce court to take jurisdiction of it?
Well,
what you did?
Her order in July of 22, it was a little bit before I got involved in it. A previous counsel was on it, but it simply said that the divorce court will not play any part of the Chancery Court case. Will not take jurisdiction.
Okay. How did they ask the court to do it? Did they ask the court to just take jurisdiction? Did they ask to combine the two cases? What did they ask to do?
Well, that was happening in July 2022, and I believe that it was actually up on a motion for bifurcation, because I think the wife's attorney wanted to have this divorce to just happen and then reserve all the issues, like all the property issues, for later. She just needed a divorce. Judge decided not to do it that time. She denied the motion for bifurcation, but included this in the very last paragraph of that order that says the Chancery Court will take jurisdiction of that case, and that this court wouldn't have anything to do with it. I think it's difficult for the trial court in a divorce to say, I'm not going to address that asset. That's an asset that is of the marriage. Clearly, the fire happened during the marriage. The divorce lawsuit happened during the marriage. All these things are happening during the marriage. I have no problem in the fact that the actual cause of action in the case has to play itself out itself in Chancery Court, but whatever resulted there should be distributed by the circuit court in the divorce. It's a hard way I don't know if that answered the question, Judge, if that makes sense.
I was trying to figure out how the parties proceeded, and I confess I haven't gone back and looked at the record, so it might explain more, but clearly the judge didn't feel like she could take part in it, and I was trying to figure out what exactly she'd been asked to do. And
at that point, I don't know what she was asked to do except to grant a divorce and a bifurcated hearing. But it was one of those things an issue that got added in, sort of like a paragraph that comes at the end of the. Yeah. And by the way, we forgot to put this in there, and it ends up being like the very last paragraph of that order of July of 2022. Okay.
Thank you.
Which brings us to the second issue. See, we were trying to get some documents from this construction account. Now, after Mr. Garrett is defaulted in the Chancery case, he doesn't have any access to these records, to these documents, and his prior counsel had filed a motion to compel. That motion to compel resulted in an agreed order that was very difficult to read and very hard to follow. It was entered on March 1st, 2023. To the best of my ability, I did my best to try to come up with what in the world this order is saying. It was number 23 reverts to number 25. I'm just using that as an example. It was one of those hard to follow orders. But the four things that he was trying to get out of that was a full set of Wells Fargo records, the records from the Weiss business, the construction account, which has to do with this insurance policy case, and then there's a home equity line of credit that was opened up in the planning of rebuilding this home, and what we're saying is that we never got a chance to get that discovery. We didn't have an opportunity to receive it. I did file a motion for sanctions, and that motion for sanctions comes on the heel of a order from the trial court that stated, well, we're just going to hold this divorce in abeyance until Mr. Garrett's criminal case gets over with. He ended up having a criminal case well into the fall. And when we show up to hear our motion for sanctions on August 1st, I didn't even have an opportunity to argue my motion for sanctions. I was cut off, and the judge decides this. We need to go ahead and just have us a trial now. We're ready to go. Everything's been done. I'm like, Your Honor, I ain't even taken a deposition yet. We haven't gotten to the point where we do that, but discovery ended up being closed at that point. And we never got any of the documents from the Wells Fargo, the business construction account. And there were some documents that were provided that were incomplete, and I believe that well, by the fact that they were incomplete, we ended up getting summaries, is what we ended up getting. And the basic summaries wouldn't tell us where this money's being transferred. We've got a shell game happening, we believe, in front of our face, and can't really pin down where all this money's going to. And
All right, Mr. Looper.
Yeah, yes,
your time is up.
Very good. And he had no access to it.
We'll hear from you on rebuttal.
Very well.
Ms. Pirtle?
Good afternoon. I'm Mary Pirtle of the McMinnville Bar Association, and I represent the appellee, and I'll try to consistently refer to the parties as husband and wife. The trial court finally conducted a hearing in this matter on October the 26th, 2023. The court entered an order, I believe, somewhere in the vicinity of 3 years and 4 months after the petition was filed in this matter. Within that order, amongst other findings, if you look at paragraph 30 of the order, which is on page 417 in your record, says the court finds that any interest in the civil suit pending in the Chancery Court of Macon County, Tennessee, refers to the file number, is the separate property of the wife. Husband has allowed a default to be taken against him, and that action has no interest in said action as far as this court is concerned, as he has abandoned any interest that he might have.
And that's the finding by Judge Byrd in the circuit court case.
That's correct, in the final decree, yes.
All right. So
And
the court basically has declared it to be her separate property.
Yes, Your Honor.
Okay.
And then,
So you're saying the court did rule?
yes,
Okay. And the ruling was based on the fact that the husband had gotten a default against him and was no longer a participant, so the whole award was to her, and the court was fine with that?
yes, the court
Okay.
made a ruling and classified that property, the interest in that lawsuit, that $79,000, as separate property. And if you also want to look at the other part of the order, and she did order beyond the findings of fact on page 10 of her final decree that the action pending in the Chancery Court of Macon County is the separate property of the wife, and husband has no interest in said action. The appellant in this case has not appealed the equitable division or classification of marital assets in this matter. I was a little confused and thought maybe that he had after I read the brief and was really struggling to respond. But he clarified in his response to my motion to dismiss the appeal in paragraph 3 of that response, it's part of this record, says that the appellant respectfully states that the issues submitted to this honorable court do not have to do with the classification of property or debt, but have to do with the jurisdiction of or lack thereof exercising jurisdiction over a marital asset. In my response to his issue 1 about whether or not the Chancery Court relinquished jurisdiction and shouldn't have, due to the fact that in a divorce the court takes jurisdiction to determine the classification of property, and I think we all know that. It's been around the law a long time. In this matter, I spent time in my discussion. I feel like I'm arguing on appeal. I mean, it just didn't happen. The court did, in interlocutory orders, make reference to the fact that she was going to allow that to happen. She was going to let the Chancery Court address those issues for good reason. The Chancery Court had subject matter jurisdiction. The husband and wife were both parties to that cause of action. And there was also another party to that cause of action.
And the insurance company can't be a part of a divorce proceeding.
Correct, I know they certainly, for my insurance defense work, we wouldn't want to be. And so, although that was done in interlocutory orders, ultimately, if you read the transcript and you read Mr. Looper arguing to the court, ultimately the court said, well, okay, I'll make a ruling. And the ruling was not to their favor. That is not before this court. That has been waived. In arguing whether the court erred in the court's interlocutory orders, the husband, through his attorney, did have some options. He could have filed a motion to consolidate the two cases. He actually could have even filed that in Chancery Court. And Chancellor Smith might have said, you know what, okay, I'm going to transfer this over and let Judge Byrd decide these issues. That was not done, as is evidenced by the record in this appeal. And the other option that could have been done, at least could have been done and could have been done timely, would have been a motion to reconsider and alter the interlocutory order under, I don't want to get my numbers mixed up. I'm referring to Rule Procedure 42 and 54. And that was not done. And then on the eve of the case going to trial, a Rule 59 motion was filed, which was in error. But ultimately, nothing was done. The two cases were left separate, probably appropriately. And the court made a ruling and classified that the insurance proceeds as separate property. And again, I believe that argument that classification was inequitable or incorrect has been waived by the appellate. As to the discovery issues, the trial court, pursuant to Tennessee Rule of Civil Procedure 26, of course, is the gatekeeper, and that rule does provide that discovery shall be limited, not may be limited, but shall be limited under criteria, obviously, the nature of the case, the issues that are before the court, and the court did not abuse her discretion. And most importantly, I guess to talk about what that rule really provides for is the discovery unreasonable and cumulative? Well, it certainly was in this case. The only assets to divide were a piece of real estate and the real estate securing indebtedness. Whether there was an increase in value and how much of the parties' retirements. And there were some personal property issues, but that was actually resolved in an earlier order than the final decree, and those were things like vehicles that you see in every case. In this case, counsel started wanting a deposition about 60 days before the final hearing. And that would have been somewhere in the range of, well, actually, I've got a note here. She ended discovery 3 years and 2 months after this case had been filed. And the court does speak, and I did quote her in my brief, about that discovery can become abusive. And she talks about the narrow issues in this case and points out, what in the world does the wife's 5 years of earnings have to do with this case? The case kept going on and on and on, and then there's new records to discover. And, Your Honor, there's no offer of proof put into this case. There was no, this is what the wife has provided me, and this is what I'm missing. There was none of that. And the only evidence in the record is the wife's testimony adamantly, I have given you everything that I can give you. I gave you all the Wells Fargos. I gave you a copy of records with Post-it notes to explain it. I gave you a new copy without Post-it notes. And even under cross-examination, she maintained, I have given you everything you have asked for. And when you look in the record, she not only did that, but she did summaries of everything to aid the court, which would have also aided the husband in the presentation of his case. And the really only issue in this case or I should say the most significant issue, would have been the husband's contribution to the home that the wife had prior to the marriage. And as the judge states, he has his own proof of that, and he didn't need the wife to produce that. She maintained she produced all of the records of where all the money went. And again, there was no offer of proof. There was nothing put into the record to demonstrate that wasn't true.
So, counsel's statement that, I believe I wrote this right, he only got summaries, isn't correct, that the summaries were in addition to the actual documents.
That is correct, and that is what my client testified to under oath, and there was nothing added to the record to refute that.
And the husband only raised 2 issues. One deals with the jurisdiction over the insurance case, and the other is whether the trial court abused its discretion in closing discovery. He's not challenging the division of the marital asset or valuation of property or anything.
That's correct. And he affirmed that in his response to my motion to dismiss the appeal. And Your Honor, we submit that the appeal should be dismissed because he has failed to appeal the categorization or the equitable division in this case. If that's not on appeal, everything else is moot, frivolous. I don't really know why we would talk about discovery or why we would talk about that in an interlocutory order the judge was expressing, I'm not going to let another case delay this case going forward. For my client, this has been a case of loss and delay. Her house burns. It's in the record, she loses her $200 and something thousand of her retirement during this short-term marriage. She spends 3 years and 4 months getting to trial while maintaining the home that he received a portion of while the case was pending on a teacher's salary. And of course we're coming up on another year now. So I have asked that her attorney fees be awarded for appeal. She was awarded her attorney fees in the lower court. And this appeal without taking exception to the classification equitable division is frivolous. And it's a pattern of conduct. If you look in the record in this case, the husband is convicted, and it's in the record, for photographing and filming my client's daughter, but he files a motion for step-parent visitation. That, of course, was never heard, but my client had to pay an attorney to deal with that. My client had to take out 2 orders of protection and a contempt while this case was pending. And again, all while trying to maintain the environment and the home that she was living in. And I understand that the high mark that it takes to call an appeal frivolous. But when you don't appeal the fundamentals of the case and you want to talk about discovery, when you put no offer of proof in at the trial court level, when the record shows that you had 3 years and 2 months to just notice the wife in for a deposition. That's all he had to do. If he wanted a deposition anytime. But the truth is, he didn't want his deposition taken. He didn't want to go to trial. But then at the last minute, he wants to delay a trial again, claiming he wants a deposition, claiming he doesn't have anything. He files a motion wanting mediation. Well, there's 2 orders of protection in this case. And the statute, as you know, we don't do mediations in abuse cases when there's order of protection. So it's the motive of this is to delay, and it is another addition of loss by having to pay me to do this appeal. And we ask that the court award her attorney fees. And I want to say, it's in my brief, but the husband did not comply with discovery timely. The wife had to file motions to compel. There was an earlier trial date that was continued. He had not complied with discovery, and the court made it very clear very early on. And my client did ask, please just give me a divorce, even if we can't have a trial about the division. She just wanted to be divorced, which was unfortunate. She certainly demonstrated a weakness to her opponent by doing that. But the court made it very clear early on, and she even ordered the parties in 2021 to complete discovery in 30 days, and it was not done. It was not done by the husband. And the delay in this case has been a source of loss for my client and a source of benefit. The husband was able to have his criminal trial prior to having the final hearing, prior to having to go under oath. And this has been an additional year, and again, the husband did not appeal any of the substantive issues in this case.
All right. Thank you, Ms. Pirtle.
Thank you.
Mr. Looper, your rebuttal.
Only briefly, just to cover a few things. I know this has taken a long time, it is true. But as being attorneys yourself and being judges yourself, you know, sometimes the time frame of things can be out of everybody's hands. It can happen that way. I understand there was a criminal case going on. I wasn't a man's criminal lawyer. I have no idea about why sometimes things take a while. They do. And I think it's probably unfortunate for both sides. But as to this being frivolous, if I don't know what I'm talking about, I can't argue what I'm talking about.
Counsel, what's to what end here, though?
Well,
Let's say that you've got the first issue. You're right that there should have, just assuming for purposes of argument, that there should have been jurisdiction exercised on the second issue that you're raising. Let's say you're right that you should have had an additional opportunity for discovery. I don't see in your brief where you've connected it up with any kind of and then what happens. So what's the, and if you're right about those things, what's the downstream consequence from it that you've argued in your brief? Because I'm struggling to see it, I gotta say. Just
as Ms. Pirtle stated, how is it that this lady is able to keep this kind of home going and manage that on teacher's salary? And I respectfully submit, probably isn't on just her salary, probably on his salary. It's probably who it's on. Because I believe the money.
Why is that relevant? Whether she
it's only relative to the extent I can't find out if.
Well, there's a lot of things I'd like to know, but they don't have anything to do with the lawsuit.
True.
And this it doesn't. Do you agree that the trial court declared the insurance claim to be the wife's separate property?
I do agree that she declared in July, and I guess she does say that in the final decree.
Well, that
but
counts.
That does count, Your Honor, but I was going on the basis of the July 22nd order where she's just not gonna entertain it at all. And
Why does your client have any business in her claim if it's her separate property? Why is that any of your client's business? Why is it any of your client's business that the wife is pursuing a claim against an insurance company that pertains to her separate property?
Okay, and it was declared her separate property, I think, in the decree. At the time, it was an issue in the.
Why is it an issue today?
Well, the issue today is that we don't believe the contributions made by the wife through these various accounts that
And how does that relate to an issue you've raised on appeal?
It relates to the fact that we believe that his contributions are substantially greater than hers, and I would have been able to try that in the trial.
And as Judge Usman said, and then how do you connect that to anything? All right. Thank you, Mr. Looper and Ms. Pirtle, for your arguments.
Thank you, Your Honor.
Call the next case, please.
Tennessee Farmers Mutual Insurance Company versus Jacqueline Hall Johnson.
Afternoon, Your Honors.
Good afternoon, sir.
Michael Fisher, Nashville Bar, Rocky McElhaney Law Firm, on behalf of the appellant. I'd like to reserve, seeing the growing